I heard that the defendant began asking my learned brother to recuse herself from the trial on the basis of being biased towards him. The judge recused herself, and the matter was assigned to this court in March 2025 for trial. Upon assumption of jurisdiction, having in mind that this matter has stayed for 10 years and the interest of justice, I granted a selected hearing. As a result of the selected hearing, I created morning and afternoon session in this court so as to accommodate this trial. The prosecution opened its case. In total, the prosecution called 5 witnesses and tendered several exhibits. The court ensured that the prosecution was kept on its toe during the presentation of this case, and same was closed on the 19th day of June 2025. It is worthy to observe that during the time when the prosecution was calling its witnesses, several adjournments were at the instance of the defendant. For instance, on the 29th day of April 2025, the defendant sought for an adjournment for cross-examination of PW1. Also, on the 2nd day of May 2025, the defendant counsel also sought for adjournment for continued cross-examination of PW1. Likewise, on the 18th day of May 2025, the defendant counsel applied for adjournment. In addition, on the 14th day of May 2025, defendant applied for an adjournment. Also, on the 21st day of May 2025, defendant applied for an adjournment as part of the options opened, or as part of options after the close of the case for the prosecution. The defense opted for the option of filing no case submission, which this court duly had after adoption of written addresses. Ruling was delivered on the 26th day of September 2025, wherein the no case submission was overruled. The issue of extraordinary rendition, validity of the charge, all were incorporated in the no case submission. After going through the no case submission, the court overruled same, and the defendant was called upon to enter his defense. In the ruling delivered on the 26th day of September 2025, the court emphasized and laid importance to the issue of fair hearing, as contained in Section 36 of the Constitution, that the defendant shall be given opportunity to defend the charge he is facing. Upon this, the defendant was called upon to do so. The court in that ruling also pointed out the need for evidence to be given on oath, to give evidence on oath to challenge the evidence of the prosecution. In that no case submission ruling, the court mentioned the importance of defendant to give evidence on oath because this is a criminal matter. It is not civil, where the standard of proof is on balance of probability. It is a criminal matter which the standard required under Section 135 of the Evidence Act 2011 is beyond reasonable doubt. It's worthy to note that extraordinary rendition is a quasi-criminal issue in a criminal case, and evidence on oath must be given, and the opposing side must be given opportunity to cross-examine on that quasi-criminal issue in accordance with Section 135 of the Evidence Act 2011. Also see the case of Edeville versus Orovoke citation supply, where the Supreme Court held that where any allegation of crime or quasi-criminal are made in any matter, even in a civil matter, affidavit evidence will be insufficient and only oral evidence will be entertained due to the standard of proof being standard required in criminal matter, which is beyond reasonable doubt. These defendants are the duty to prove the allegation of extraordinary rendition in this criminal matter beyond reasonable doubt. The defendant has not called anybody to testify on oath in respect of extraordinary rendition, which would enable the other side to cross-examine such witness. The failure of the defendant to give evidence on oath on extraordinary rendition has made the allegation bare. It is simple and assertion without proof. The court was constrained to deliver the no case submission ruling earlier, as during the vacation of this court, the defendant has filed an application that he be moved to a private ward in the National Hospital, Abuja, as the facility of the Department of State Security Service were not adequate to take care of his health. The court had quickly rushed back due to the importance of health of the defendant. The court ordered the president of Nigerian Medical Association to constitute a panel of experts to carry out tests on the defendant to ascertain his health status and whether he is fit to stand trial. The need to ascertain his fitness to stand trial was based on the antecedents of causing delay in this trial. The court was suspicious whether the issue of medical reports raised at that stage was empty of the ruling and laying foundation for usual delay, which has been the trend since 2015. Based on this, the court added that the medical panel ascertained whether the defendant is fit to stand trial. It is actually a mystery to this court that a defendant who is standing trial would delay his trial, his own trial, while shouting that he is being denied his right to fair hearing. Usually, it is the prosecution that delays the trial as his life is not on the line. But in this case, the reverse was the case. The order of the court to ascertain his fitness was strategic to nip in the bud any attempt by him to further delay his trial. On the 16th day of October 2025, the court ruled on the medical report issued by the panel set up by the president of the Nigerian Medical Association and determined that the defendant is indeed fit to stand his trial after no opposition from the defendant and the prosecution as regards the reports. The court had carefully observed the defendant during the entire trial and the spirited nature of the defendant. His unruly attitude and his agility in defending himself shows without that he is indeed fit to stand trial. Thus, corroborating the conclusion reached in the report by the panel set up by the president of Medical Association, even without the medical reports, the fitness of the defendant is clear to any reasonable person who observed him in court. His claim of being low on potassium or other nutrients as stated in his supporting affidavit to his application for transfer to National Hospital are not such that render him incapacitated from understanding the proceeding in this trial. He is healthy, fit, and abreast of all the happening in the trial, and demonstrated full understanding and fitness after taking over his defense himself from his counsel. I therefore hold, without doubt, that the defendant is fit to stand this trial. The court then proceeded to give the defendant 6 consecutive days to open and close his defense. Counsel to the defendant, Chief Kanu'S, had prayed the court to allow the private consultation between the defendant and his counsel in preparation for his defense. Despite the fact that there was no evidence before the court of the DSS dropping on the conversation of the defendant and his counsel, the court graciously asked the defendant and his counsel to use the courtroom for their pre-trial meeting, since they felt more comfortable in the court. The development meant that the court had to clear the courtroom, and it meant that the court could not conduct hearing in the morning of 22nd day of October 2025, just to accommodate the defendant and his counsel. The court then adjourned the hearing for 23rd, 24, 27, 28, and 29 and 30th October 2025 for the defendant to open.
All right, guys, this is live update of Nnamdi Kanu's judgment today, November 20. Justice James Omotosho will give judgment on this case today. As you can see, he's reading out the judgment, and we are getting closer to the end of the judgment. So we'll be right back. Please keep watching, keep subscribing, and keep sharing. Thank you. This is Prospect Channel TV.